of them responded to the email. So, all right here. Hey, everybody. It's me and Jesse. It's the Jesse and Chuck show.
Yep.
Great to be here. And half a cow. It's Jess. So I guess we're not talking about the decision in the Go and Gomez case today.
Not unless it's come up. No, we're not. Nope.
We're not talking about that. Somebody asked me yesterday in an email, when we win the appeal, the next day they can get a visa, right?
Yeah, there's a lot of hypotheticals in there. If and maybe at some point would be my answer. But yeah, no, I mean, I know it's the same old story. No need to repeat it. I know it's just I think people are probably sick of listening to us.
Well, I'm sure they are. Another person emailed said they had come into the country illegally to seek asylum. Can they still benefit from the decision? The answer is no.
Yeah, it's gonna be tough.
That's an SOL kind of thing. But we just, we keep the faith. We believe in our case, and just know that if we lose, we appeal. If the government loses, they appeal. I'm just certain that's going to happen. But
yeah, I think that's right. I think it's right.
A couple other things. We are obviously still on hold on the 601A litigation. We're waiting the Ninth Circuit. I think briefing is due final this Friday in that case. From the government, and then oral argument I think has not been set yet, has it, or hasn't been set?
I don't think so.
But Ninth Circuit's very efficient on stuff like that.
They expedited that appeal, and the Fourth Circuit case is also complete. And I don't know if they've set argument there yet. I don't think they have, but yeah, those decisions are gonna. I mean, what does expedite mean? I guess, right? But
my experience in the Ninth is that means they'll probably have a hearing before Christmas. If not,
they should. They should. I mean, they have to set it. It'll probably be, in Pasadena. But yeah. I mean, there were a couple interesting developments, though. I mean, one good, one bad. Nebraska granted a motion to dismiss, and that's going to affect our 601A case.
That'll affect this case, the 601 case.
601A, though, it was a 601A, and the judge had some kind of different reasoning than all the other cases where he dismissed it, but he really did it on the merits. He didn't necessarily agree with what the government had the discretion to never adjudicate. Nevertheless, found that this was really about priorities, and because it was priorities, then he should just dismiss it nonetheless. I actually think I said this to you, and I think some others. I think he wanted to deny the motion to dismiss and just couldn't get there.
He didn't want to open up the floodgates, maybe.
And he had to write a decision. I think probably. Our pending 601A case, 601 case, where we have 4 people left, I think that may have influenced them. These judges talk behind closed doors. So do the clerks,
unfortunately, they don't talk to us, do they?
No. Well, they should. I hope not. But here's the other thing, though, and we've said this before, and now we have some evidence of this. So in the Colorado District Court case where the judge denied a group-based 601A case, the judge denied a motion to dismiss and granted some discovery. And again, discovery was going to go into what exactly are you doing with these 601As? It looks strange. Tell us more. And you get evidence from the other side. Well, USCIS just agreed to adjudicate the remaining 14 petitions. And
in 30 days. In 30 days, they would adjudicate them all.
And, that's going to obviously piss off our clients because they're not included. But, I can understand that. On the other hand, it's further proof, though, that they're not going to follow a rhyme or reason because those petitions, a lot of them, I think, were 21s and 22s.
Oh, no, a lot of them were newer petitions. And it's quite clear that this is the same thing that happened in the EB-5 case.
Sure.
We lost the motion to dismiss, and they just adjudicated all the cases.
Sure. No, and that's and that's where we were headed with this, and I think we're still headed there. And it's it's further proof in my mind, though, that litigation does work. Doesn't necessarily, doesn't mean it works every single time you do it, but your efforts out there in the Northern District of California and the good efforts here in Colorado, they work, and they're going to work for us if the circuit courts have their druthers about them. So
I think so. And talking about litigation that works, let's talk about the new H-1B lottery rules that just came out. And oddly enough, I wish Craig was here because he could be gloating right now, as he should, with the forcing of the hand at USCIS to change their freaking H-1B lottery. Yep. And sure enough, they're adopting Greg's measure in toto. Just count the beneficiaries. Yeah. I think this is, it's a good, the rule itself, there's lots of other issues with it. And I just did a podcast this morning that I put up on my page about this, but the lottery change is fantastic. Now, one thing they did in their rule is they disclosed more information about the applications the last several years. So information we never had before, which was how many people applied with multiple applications and how many multiple applications. That's really kind of thing. And they had some people apply like 10 times for these things. But they had 305,000 single applicants. So, and if you add all the other duplicates together, it's on 140,000. So even though they're going to only count beneficiaries, they're still going to accept multiple applications. Yeah. As a beneficiary, you only get one bite at the apple. But I would suspect they're probably going to get well over 400,000 H-1B slots next year. Well over. Yeah. Now, the odds are now fair, which is great. Which actually, I think if I'm a lawyer and somebody comes to me and says, should I file for the H-1B? 100% you should file for the H-1B. Because, and if you were thinking about maybe I won't, maybe I will, you should. Now, Jesse, the one thing oddly enough missing from this proposed regulation is the fee. They didn't indicate what the fee would be for next year's lottery. Now, maybe they're obviously reserving that for, I guess, the fee increase or separate rulemaking. But it seems a little loco to me that they didn't put that in the rule that's going to be in effect for the next lottery.
Yeah, I guess my thinking is this. There's a lot to that rule. And I don't know if they're going to end up doing like an IFR, an interim final, so they can get this, because, the lotteries, it seems like we have a lot of time, but we really don't. Comment period is December 22nd. And then they have to take and consider the comments, which aren't necessarily going to be directed at just the registration.
Oh, there's 316 comments already.
Yeah. So do they separate the lottery change out and do it as an item?
Can they do that?
I think they could if it turns out that the timing doesn't work. Because here's the situation, right? Is there sufficient cause for them to change the system immediately and implement the change? Yeah, right. Well, and here's an interesting issue, because I represent some beneficiaries. Because what has happened, good or bad or indifferent. I really don't want to get into the merits, but what has happened is this: people who were the beneficiaries and whose name was put in multiple times, multi-registration, they 2-3 years ago, maybe, they accept employment, they've been on an H-1, and then they get it revoked because the first employer doesn't respond or whatever, and they engage, and USCIS alleges that there's been fraud. Well, we think that fraud finding can actually affect the beneficiary who's not even notified. Then they lose their cap number. And so I'm in a case right now where we're trying to remove both. And, the government actually has come out and said, well, we won't hold them as inadmissible, your clients, not everybody, because we have people who actually have been found 6C, and they say it's because of the multiple registration, even though they never had a communication. So, I think it's good for everyone to reset the table. There's going to be a lot of fallout because of what has happened over the last couple of years. But I absolutely 100% would support, no one's going to ask me, but I would support, like, they're going to have to deal with this issue prior to the next registration and allow employers sufficient head time or lead time to not only know what the fee is and do it.
Well, the thing is, the lottery is March 1.
Right.
I mean, that's only 66 days after the end of the comment period.
There's not going to be, they're going to have to do something else. And I think they probably know that.
I think you're right. I think you're right.
Because the other part of it is too, that specialty occupation change is not great.
That's litigation right there, man. That's going to be litigation. Well, how about this? I mean, you probably realize this. Mandatory FDNS compliance. Mandatory.
Who's funding that?
Great question. Look for a massive fee increase on the H-1Bs this next year. They had some charts in the proposed rule that from 2009 till 2019, when they did FDNS visits, there was like an 11% non-compliance or fraud or whatever. But that from 19 to 2022, it was a 34%. I don't believe that for a second, honestly. And to lump in, quote, non-compliance with fraud is completely ridiculous.
Yeah.
Completely ridiculous. But it's mandatory compliance. While there are some good things in that rule, there is no statutory basis for FDNS to even exist.
Yeah.
And I think I sense litigation coming.
It's hard. I mean, I see it. I don't do these petitions. I don't represent usually businesses in that capacity. But for me, it just seems like the little guy, and I say little guy, I mean employer, is it makes it almost cost prohibitive.
Well, no, it's clearly that's one of the intents. That's why some of this stuff comes from Trump. So clearly that was the intent, to make it a super undesirable thing to do.
Yeah. But I mean, at the end of the day, like, who needs those employees most? Because if you can't, you're struggling, maybe you employ people on CPT or OPT, it kind of has this effect of freezing out startups and those tech companies, and it gives these H1s to just the big boys who don't even need them.
Now, there is one, actually, I think, fantastic rule change, finally, which allows for self-employed H-1Bs. That's fantastic. If you're a majority owner of a business, you can file your own H-1B, and you don't even have to spend all your time doing H-1B work. You can just have to spend 50% of your time doing H-1B work.
That's huge.
So there's because I represent people, and I've done self-employed H-1Bs, except they allowed them, then they specifically prohibited them, then they winked an eye at a couple of them, but now they're making it regulatorily approved. That's a good change. So
let me ask you a question. Now, if is that going to, because I assume when you register, you don't have to submit the proof that you have this ability, right? I mean, is it going to drive up?
You just have to submit the name of the employer who's going to hire you. Right?
So are people who maybe here on F1 are looking for a status after they graduate, are they just going to put their names in as self-employed and then find that, they're going to create the parachute after, they're going to.
Well, you create the company and then you name it, you're an LLC, you get a tax ID number, you can file in the lottery.
Sure.
Now, there is a crazy ass change in these regulations that require you to, when you file for an extension, to prove that you maintained your status the whole 3 years.
Holy
so
shit.
So they said, things like your pay stubs. What, you want 3 years of pay stubs or quarterly? No employer is going to release quarterly tax reports to the USCIS. It's a massive paperwork flood to add to the H-1B extension program. Again, to make it more difficult.
Absolutely. I mean, that's going to be ridiculous. They're going to have to come out with, that's one where I could see a lot of comments being like, listen, you don't even understand how people get paid. It's going to be,
it's ridiculous. I can see that coming out of FDNS. But this is why the Department of Labor Wage and Hour exists. If you're not getting paid because you're not working, they should be going to the Department of Labor and making a claim for those back wages.
100%.
That's what should be happening. But
right.
Of course, wage and hour isn't funded basically at all. So,
they're no joke. I mean, I've represented some employers who didn't do the right thing and had,
I represented a couple of people who hired me, and
yeah,
they wrote very large checks.
absolutely. Yeah. They're no joke. Yeah.
No.
And the consequences actually of not settling or going to a contested are just too great. I mean, that's why. So I don't know. It seems like duplicative, you know?
Well,
yeah.
There you go.
Anyway.
Let's take a couple questions here, Jess. Let's see. Go up here to the top. If I can get it to work. There we go. Danny says good morning. And T. Lyon said good afternoon. Omar, good afternoon. As always, we know nothing about TV or positive words. The positive words, we believe in our case. It's limbo time. Jesse, have you seen the last opinion published by Judge Henderson on January 6th, about January 6th? She said no proof of the insurrection had intention to corrupt and make benefit to Trump. I don't really know
I
what
haven't
that means.
seen it, but I mean,
that doesn't surprise me about Henderson at all.
Absolutely, yeah.
We're not getting Henderson's vote anyway.
No, I mean, she's like the Kool-Aid guy. She's the guy, she's the big red. She's got the big red suit on. She's filled with the Kool-Aid. No. That's not surprising.
That's not. We are very worried because it's the Middle East. Yeah, I mean, a lot of our plaintiffs are in the Middle East, and it is dangerous. And our prayers and thoughts are with you. We can't do much more than that at this point, though.
Yeah, I can tell you though, I do see again, there's a crisis and it's terrible, but I do think if you're in processing and you're already aggravated at the delay in processing a visa, and you live in anywhere in the world, probably it's going to be slower because State Department has going to have to shift some resources around.
Yeah. Even when we win and the government doesn't appeal, which I don't think is going to happen, it's still months before you're going to get any appointments at consulates. I mean, it's just the way it is. Emily, how you doing? Jesse and I kind of answered this. If it would require an interim final rule.
Yeah.
On this issue alone, because there's no way they get the rest of this stuff done by then.
I mean, I guess the only other way is they could do it like they have been, and I think employers would be very just, kind of like, all of them who didn't file petitions that were selected,
right?
So maybe they just won't. I don't know, but I if I were the agency, which I'm not, thank God, I would make the change for the next registration.
Emily also asked why the USCIS hasn't responded to my FOIA on F-45 by category. Well, they haven't had it all that long. Immigration does take, and I haven't sued them on. I could sue them tomorrow on it, but I'm gonna give them a little bit more time to get me this information. Because Jesse, the reason this FOIA exists was because when they list on currently pending cases, they just put 45. So you don't know how many are employment-based. You just don't have any idea, and under which category, which is obviously vitally important.
Oh yeah.
I wrote a blog that LexisNexis picked up for BIB Daily on the visa apocalypse. That if you're a rest of the world EB3 and you file today, start today the process, you probably got 10 years, 7 to 10 years before you're getting a green card.
Yeah,
that's the apocalypse. That's the apocalypse. Yeah. And India, I established, is 210 years for an EB3.
Jeez.
Yeah, nuts. What do you know? What month and year U.S. is working on pretending? I thought I saw that some early April 2020s were being approved. Caroline.
Yeah. I mean, they're not really following a rhyme or reason except for our plaintiffs. So,
yeah,
I mean, it depends, for our clients, I think I'd have to ask Greg.
Yeah,
but
so Eric is answering. She's got to march. See, this again, they're not doing them in order.
No,
they're clearly not. Again, we put that evidence in front of the judge.
Yeah,
we're literally waiting, kind of in this kind of limbo land, unfortunately.
Yeah.
Daniel, we briefly touched on this earlier in the show here, but our lawsuit. I mean, we're fully briefed before the judge.
That new decision is gonna,
same judge, right? It's the same judge.
Is it Rossiter or whatever? Rossiter?
Yeah.
Yeah, it hurts. It really does. I mean, it's not good for us.
But
So
what's odd is we didn't get one about the same time. I mean, that's been out for 2 weeks. It's just strange that ours is still percolating.
I think reading between the, I don't know. I mean, I hate this. I always do this and speculate where I shouldn't, but I mean, the guy seemed really reluctant to issue that decision, and maybe he looks at our case and says there's four I call them kids, but 4 clients there, and he's just gonna, play chicken with the agency, and hopefully the agency will just adjudicate the rest of them. But
We'll see. We'll see.
It'd be worth appealing. I mean, the 8th Circuit's really tough. Don't get me wrong, but it would be worth filing a notice.
It's not the 5th, man. It's still what's going on.
To be honest, I actually think the 5th would be a pretty good circuit for this like crazy jurisdictional argument. Because what you're telling, I mean, conservative judges, I say this all the time, like Gorsuch and the rest of them, conservative judges hate when an executive agency tells them they cannot do something.
That's true.
And what the government is saying is, courts, get out of our business. We're going to be fine. Just trust us. That's, I mean, just trust us.
Trust us. We're the government. We're here to help you.
Yeah, exactly.
Emily, we talked about the startup briefly a little bit earlier. I don't think that this is an abuse. First of all, they're going to get super strong scrutiny on this about self-employed H-1Bs. But I've done them. I mean, I've probably done them a couple dozen over the last 35 years while they were doable. And the reality is, it takes a serious set of cojones to set up your own business, and to have a business plan, have an independent board of directors. I mean, this is an immigration. They might only approve it for a year. They can do that.
Yeah.
So we'll see. I don't see it as abuse. I see it as an opportunity, honestly, to welcome. For example, every year I give a talk at Emory, the MBA program, when they graduate. Every year they got 20 or 30 MBAs graduating. Yeah, some are going to go work for big companies, but others just, man, I've got an idea that I think can make cash, can make serious money, could really impact America. Why shouldn't they be able to do an H-1B?
Wow.
So,
it's weird, right? At the same time, didn't they just change the rules for self-prop L1As?
they could, but I mean, and the
No, they
rule change
did,
for
though.
L1As was you can't be self-employed.
Yeah.
But if you form a company, you can, and you're the only shareholder, you can do it. It's like, what?
Yeah.
Doesn't even make any sense. Doesn't even make any sense. I don't think, Caroline brings up they're only working on final action dates that are current. I mean, almost everybody would be current. I mean, these are generally speaking immediate relative cases.
Yeah, or F2A.
So,
I mean, I
F2A
would have.
and,
that's not even retrogress, really, right? I mean, that's
F2A is a retrogress, but they weren't filed. They weren't retrogressed. At least the ones 3 or 4 years ago. So I don't see them doing. And then if they're doing that, they're going to get their asses sued. I mean, that's ridiculous.
They haven't said that.
No,
that's kind of like
not.
the visa availability approach. They haven't. They would have to tell us that.
Yeah, well, Emily, I could see people doing self-employed H-1Bs in lieu of day one CPTs. You know what? If the law allows it,
it'd probably be easier than doing the 1-day CPTs, right?
Well, especially it's just all the scrutiny that day one CPTs get from USCIS.
Yeah. Yeah.
We'll see. Thoughts on the House Speaker situation?
I mean,
what the heck? No. Other than I don't know how this guy is any better than Jim Jordan. They have an identical voting record.
Yeah.
Right. This guy even led the charge to file the brief in the Supreme Court attacking the election. So if these weak-willed Republicans that voted against Jordan vote for this clown, then they really have they've got no morals whatsoever. They have no standard whatsoever. So
I do think the government will likely shut down, though.
Well, I think with this guy as the House Speaker, they will.
Yeah.
Oh no, for sure. Which is going to kill the Republicans. It's going to kill the Republicans. It always does.
Yeah.
Third lottery. That's a good question. I just say H-1B lottery. I don't know. It's those numbers have not been released. How many people applied in the second? They're still within the 90-day period of the second lottery.
Or with through. A lot of people are withdrawing them.
Yeah. So I mean, I personally think they will have a third lottery, but I don't know. Good news about DACA. There's no news about DACA. It's DACA's interesting. I know you probably don't follow this too closely, Jesse, but DACA is one of my things, and we're waiting on the appeal and then the briefing at the Fifth Circuit again on Texas versus Mayorkas, or Texas versus U.S., whatever they're calling the case these days, because Judge Hannon basically ignored the Supreme Court's recent rulings on jurisdiction.
Yeah.
So, the Supreme Court rules that Texas has no authority to challenge a policy memo on priorities of removal. Okay. And yet he rules that he does have jurisdiction to rule on DACA, which is exactly the same thing.
Yeah.
It's priorities. It's exactly the same thing. I don't see how the Fifth Circuit can legitimately not overturn Hannon, and no way SCOTUS doesn't overturn him, in my opinion.
Yeah, I think it's a really good case for appeal. I mean,
now
the standing arguments are going to be tough to get around. I mean, I don't know how the states can distinguish
but it costs, they have to get driver's license in Texas, and it costs us money. What? Don't you pay for a driver's license? Wait until May 2020 release for scheduled interviews. Begin the process for D. I don't know what's going to. Rocks, hoping that not a lot of people apply for 601A during the pandemic. No, there's
so many
mountains. There's so many. There's 140,000 pending cases.
Yeah.
I mean, we know how many. We know. But, they did promise a few weeks ago, within 12 months, it will not take longer than 12 months to do a 601A.
Yeah. Yeah, that's never going to happen. I mean, they'll game the system. Like I said, I've said this before, they'll game the system and start doing them last in, first out. And that's how they'll get the times down. But it won't be real. They don't have an ability right now to handle 140. The other thing, too, is even if they did, right, we talked about the visa bulletin and the apocalypse, and you brilliantly described it. I mean, that we'd create one in the family base. I mean, unless they're all, I mean, the immediate relatives may be different because they're not really, but it would impact, the availability of visas, and they're just not going to do them like that. They're not going to.
One of the interesting things about the visa apocalypse is immigration just slyly said publicly that because there are so many, for employment-based cases, so many pending adjustments, that there will basically be no movement in the visa bulletin for employment-based category this year. There's just so many cases pending.
Yeah, no. I mean, I absolutely 100% believe that.
All right, the last question here, Ted. Do I know the receipt dates? Ted, Ted Lyons is actually a friend of mine. I call you Ted. I just T Lyons. Maybe your name is Ted. I don't know. I don't know the dates. That's Aaron's specialty.
My son's name is Ted. So.
Oh, is it really? That's a great name. I love the name Ted. That's just great. Now you have twin sons, of course. And what is the other's name?
Matthew.
Oh, that's great names. Great names.
No.
His kids are super, super cute, super good looking boys. Baseball stars, right?
Yeah, they're trying to be. Awesome. They're good. They're going to be 13 next month.
That's awesome. That's awesome. Yeah. And how about that exciting World Series between the Texas Rangers and the who are they? Diamondbacks. Boy, that's a thriller right there. That's one I'm going to tune into.
Yeah. I don't know. Boston is we were so spoiled that it's tough for me to complain. But
we're spoiled in Atlanta. We always have great regular seasons. We got lots of division titles, so to speak. But
you have a great fan base, though.
We do have a great fan base.
They love the Braves. They do.
They do. All right, Jess, been great to see you today.
All right.
Next week I may be here. Jesse may be doing it alone for all I know. I don't know.
Oh,
we'll let if we're even on. But I think Greg is with me out of the country next week, so it will be 5 or 6 hours ahead. Probably still do it. And Aaron, I don't know if Aaron's going to be there either, but maybe Aaron's coming too. I don't know. Jesse's not coming though. Jesse has to stay in Boston and hold the fort down.
Yeah. No, I'll be here. I'm happy to do it.
Jesse, you're up.
Of course, you know what's going to happen now.
Oh, no, we'll get 15 decisions all at one time.
Yeah, Gomez and Good Luck and Go. They'll all come
and the
out.
601A case and the 601 case will all come down to
60,000 people on it. I'll have to actually put on a nice shirt, and what the pressure now. But you know what would happen. It would happen. I'm happy to do it though. Let's do it.
All right, we'll see you guys next week. Bye-bye.
Bye-bye.